You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Domain 6 brings together the threads of law, risk, and compliance, weaving them into the framework that governs cloud operations. Technology alone cannot secure an enterprise. It must operate within legal mandates, reflect organizational risk appetite, and prove compliance to regulators, auditors, and customers. This domain provides that structure. Its purpose is to ensure that decisions made in cloud adoption are not just technically sound, but also legally defensible and aligned to business objectives. Just as pilots must not only know how to fly, but also follow air traffic rules, cloud professionals must balance operational efficiency with regulatory and contractual obligations. This domain establishes the guardrails that allow innovation to flourish responsibly. By studying Domain 6, learners understand how governance structures, legal requirements, and compliance systems interlock to make cloud security not just effective but also sustainable and lawful. The scope of Domain 6 is broad, covering governance structures, contractual agreements, privacy obligations, risk management, audits, and regulatory requirements. Governance ensures organizations have coherent policies and oversight processes. Contracts and service agreements formalize expectations with providers. Privacy laws dictate how personal data must be handled, while risk management frameworks guide decision-making under uncertainty. Audits verify whether controls are working as intended, and regulatory frameworks impose industry-specific rules. The scope is intentionally comprehensive because in cloud security, failures in one area ripple into others. A weak contract may leave gaps in liability, while poor governance may cause compliance drift. Imagine an orchestra. Governance is the conductor, contracts are the sheet music, and privacy laws are the tempo. All must work together in harmony. Domain 6's breadth emphasizes that legal, risk, and compliance are inseparable pillars supporting trustworthy cloud programs. Governance, risk, and compliance, often shortened to GRC, provides the coordination framework for policies, controls, and oversight across an organization. Governance sets the tone by defining rules and accountability. Risk management evaluates threats, vulnerabilities, and impacts, ensuring decisions reflect organizational appetite and tolerance. Compliance verifies adherence to laws, regulations, and internal standards. When integrated, GRC ensures organizations move deliberately rather than reactively. For example, governance may dictate that encryption is required for sensitive data. Risk management quantifies the consequences of failing to encrypt. Compliance confirms that encryption practices meet regulatory expectations. This coordination resembles a three-legged stool. Remove one leg, and stability is lost. GRC is particularly vital in cloud contexts, where services are distributed across providers and geographies. Without structured coordination, organizations risk fragmented policies, inconsistent controls, and audit findings that undermine both trust and resilience. Enterprise Risk Management, or ERM, applies these ideas to the entire organization by defining risk appetite, tolerance, and treatment strategies. Appetite represents the level of risk the organization is willing to accept in pursuit of objectives. Tolerance defines thresholds where intervention is required. Treatment strategies outline whether risks will be mitigated, transferred, accepted, or avoided. In cloud, ERM influences choices such as whether to store sensitive data in certain regions, how to evaluate third-party vendors, or whether to purchase cyber insurance. ERM aligns technical decisions with executive vision, ensuring cloud adoption does not outpace organizational resilience. Think of ERM as a thermostat. Leadership sets the temperature range, and operational teams adjust controls to maintain conditions within that band. Without ERM, risk decisions become ad hoc, leaving organizations vulnerable to surprises and unable to justify choices to regulators or shareholders. contracts, and service-level agreements formalize expectations between organizations and providers. These documents codify responsibilities for availability, support, remedies, and liability. An SLA may guarantee 99.9% uptime, define maintenance windows, and outline compensation if targets are missed. Contracts may address security controls, incident cooperation, or data ownership. Without precise language, organizations may assume protections that do not exist. For example, a provider may guarantee service availability but not data backup. Contracts clarify these boundaries. They are the legal equivalent of blueprints in construction, ensuring both parties know what will be built, who is responsible, and how defects will be handled. Effective contracts provide not only assurance but also leverage, enabling organizations to hold providers accountable. Weak contracts, by contrast, shift risks unfairly and leave organizations with limited recourse when failures occur. Privacy regulations form another core focus of Domain 6. Laws such as the European Union's General Data Protection Regulation and the California Consumer Privacy Act impose strict duties on organizations processing personal data. These include requirements for lawful bases of processing, rights of access and erasure, and obligations to protect data against unauthorized access. The penalties for violations can be severe, including multi-million-dollar fines and reputational damage. In cloud environments, compliance is complicated by distributed infrastructure and shared responsibilities between provider and customer. For example, GDPR requires that individuals can request a deletion of their personal data, but if that data spans multiple cloud regions, processes must ensure complete fulfillment. Privacy regulations ensure that innovation does not come at the cost of individual rights. They remind organizations that data is not only an asset but also a trust held on behalf of people. Within privacy frameworks, the roles of data controller and data processor determine legal responsibilities. The controller decides the purposes and means of processing personal data, while the processor acts on behalf of the controller. In a cloud context, an enterprise using a provider to host customer data remains the controller, while the provider functions as processor. This distinction clarifies who must respond to data subject requests, maintain records, and report breaches. Confusion between the two roles can create compliance gaps. For example, if a controller assumes the processor will handle deletion requests, but the contract says otherwise, obligations may go unmet. Understanding these roles is like knowing who holds the steering wheel versus who controls the pedals. Both contribute, but accountability differs. Clearly defining controller and processor duties is essential for avoiding disputes and ensuring compliance in shared responsibility environments. Records of processing activities, or ROPA, provide documentation of how personal data is used within an organization. These records must include details such as processing purposes, categories of data, recipients, and retention periods. Under GDPR, maintaining ROPA is mandatory for many organizations. In practice, these records act like an inventory log, mapping where data resides, how it flows, and who touches it. In cloud environments, ROPA ensures that organizations can demonstrate transparency, both to regulators and to customers. For example, if personal data is transferred to analytic services, ROPA documents this purpose and the safeguards applied. Without such records, organizations cannot credibly prove compliance or identify risks. Maintaining ROPA is akin to keeping receipts for business expenses. Each entry supports accountability and enables audits. In the cloud, it also ensures visibility across complex multi-service data ecosystems. Cross-border data transfer mechanisms address the reality that cloud often involves global infrastructure. Privacy laws restrict data leaving certain jurisdictions unless adequate protections are in place. Mechanisms such as standard contractual clauses and binding corporate rules provide legal grounds for transfers. SCCs are pre-approved contractual commitments between parties, while BCRs are internal codes of conduct approved by regulators for multinational groups. Both aim to ensure data receives equivalent protection abroad. Without these mechanisms, organizations risk unlawful transfers, which can lead to fines and forced suspension of services. This challenge resembles sending goods across borders. Customs laws must be respected and documentation provided. Cross-border mechanisms create the legal paperwork that allows digital information to flow lawfully across jurisdictions. In the cloud era, where data location may be dynamic, these mechanisms are vital to keeping services both global and compliant. Legal hold and e-discovery obligations highlight the intersection of law and technology. When litigation is anticipated, organizations must preserve relevant electronically stored information, or ESI, to prevent spoliation. In cloud environments, this includes emails, logs, documents, and application data. E-discovery requires that preserved data be searchable and retrievable for legal proceedings. Implementing legal hold in cloud systems involves coordination with providers to suspend deletion or modification of targeted data. Imagine freezing a crime scene. Nothing can be altered until investigators complete their work. Legal hold provides that freeze for digital evidence. Failure to comply can lead to legal sanctions and weakened positions in court. Cloud professionals must understand these obligations, ensuring technical systems support legal processes while balancing operational impact. Legal hold bridges the gap between compliance theory and the realities of litigation. Assurance frameworks provide external validation of controls. Standards like ISO 27001 certify information security management systems, while society reports provide independent assessments of a provider's controls. Customers rely on these reports to evaluate provider reliability and compliance alignment. For example, a Society 2 report may demonstrate that a cloud service maintains controls for confidentiality and availability. These frameworks are like inspection stickers on cars. They do not guarantee perfection but indicate that minimum standards have been met by trusted authorities. Relying on such certifications streamlines vendor assessment, reducing duplication of audits across customers. However, organizations must interpret assurance frameworks carefully, recognizing their scope and limitations. Not all controls may be tested, and reports may cover only specific services. Assurance frameworks complement, but do not replace, an organization's own due diligence in risk management. Sector-specific regulations add another layer of obligations. Healthcare organizations must comply with HIPAA, which dictates controls for patient data privacy and security. Retailers handling credit card transactions must follow PCI DSS, a global standard requiring controls such as encryption, logging, and vulnerability scanning. These rules exist because sector risks differ. Health records carry different sensitivities than payment information. In cloud, compliance requires both technical controls and contractual commitments with providers. For example, HIPAA-covered entities must have business associate agreements with cloud vendors. Sector rules are like specialized building codes. Different facilities require different safeguards, from hospitals to financial institutions. Cloud professionals must map these sector obligations into their architectures, ensuring compliance is maintained without compromising efficiency. Ignoring sector-specific standards risks penalties, litigation, and loss of trust within highly regulated industries. Breach notification laws define how organizations must respond when security incidents expose personal or sensitive data. Requirements typically specify who must be notified, within what timeline, and with what content. For instance, GDPR requires notifying supervisory authorities within 72 hours of becoming aware of a breach, unless it is unlikely to result in risk to individuals. U.S. state laws often require notifying affected residents directly. These obligations mean that incident response plans must integrate legal considerations alongside technical ones. Imagine a fire drill where, in addition to extinguishing flames, the team must also notify the fire department and occupants promptly. Breach notification ensures transparency and empowers individuals to protect themselves. Failure to meet timelines or content requirements can compound penalties. making legal readiness a central part of security incident management. Digital evidence management plays a critical role in cloud compliance and litigation. Logs, audit trails, and forensic artifacts may become evidence in court or regulatory investigations. For such evidence to be admissible, organizations must maintain chain of custody, proving integrity from collection through storage. Admissibility requires that evidence is authentic, reliable, and relevant. In practice, this means securing log files against tampering, documenting who accessed them, and preserving them in immutable formats when necessary. It is like sealing physical evidence in tamper-evident bags, with custody records signed at each handoff. Without proper handling, evidence may be excluded from proceedings, weakening cases, or compliance defenses. Cloud professionals must design systems where logging not only supports security operations, but also satisfies evidentiary requirements, aligning technical practices with legal standards. Codes of ethics and professional conduct extend governance into the realm of individual behavior. These codes articulate duties such as maintaining confidentiality, avoiding conflicts of interest, and exercising due care in decision-making. For cloud professionals, adhering to such codes builds trust with employers, clients, and regulators. Ethical conduct ensures that technical expertise is applied responsibly, avoiding shortcuts that may undermine security or compliance. For example, knowingly ignoring encryption requirements to save time would violate both professional ethics and organizational policy. Ethics codes resemble medical oaths. While not always legally binding, they establish standards that define professional identity and accountability. In fast-changing fields like cloud security, where legal frameworks often lag behind technology, ethical codes provide enduring guidance. They remind professionals that integrity is as critical to resilience as technical skill. A policy hierarchy ties governance together by aligning policies, standards, procedures, and guidelines. Policies set high-level principles, such as requiring data encryption. Standards translate these into measurable requirements, like specifying AES 256 as the encryption algorithm. Procedures provide step-by-step instructions for implementation, while guidelines offer best practices. This hierarchy ensures clarity, consistency, and traceability. Without it, organizations risk fragmentation, different teams interpreting policies in inconsistent ways. It is like building a house. Policies are the design vision, standards are the blueprints, procedures are the construction steps, and guidelines are advice from experienced builders. In cloud environments, mapping policy hierarchy to control objectives provides assurance that governance intent translates into technical reality. This structure is essential for audits, as it demonstrates not only that controls exist but also that they align with documented organizational commitments. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Risk assessment is the practical tool that brings enterprise risk management to life. It identifies threats, vulnerabilities, likelihood, and impact for systems and services, documenting assumptions and assigning owners for each risk. In cloud, threats might include misconfigured storage buckets, vendor outages, or insider misuse. Vulnerabilities describe weaknesses, such as insufficient logging or excessive permissions. Likelihood reflects probability, while impact measures consequences for confidentiality, integrity, and availability. Risk assessment is not a one-time event, but a continuous process that evolves as services and threats change. Think of it as a medical checkup. Assessments catch problems early, suggest treatments, and track health trends over time. By documenting results and assigning ownership, organizations ensure accountability. This transparency makes it clear who is responsible for remediation and how decisions align with risk appetite. Effective risk assessments transform vague concerns into actionable priorities. Control objectives translate legal, regulatory, and risk requirements into tangible technical, administrative, and physical safeguards. For example, a legal requirement to protect personal data might translate into an objective to ensure encryption in transit and at rest. Control objectives act as bridges between abstract requirements and operational reality. Without them, staff may not know how to implement compliance obligations effectively. They also provide audit checkpoints, since each objective can be mapped to specific controls and evidence. Think of objectives as the what and controls as the how. For instance, the objective may be to restrict access to sensitive systems, while the control specifies multi-factor authentication. Cloud environments magnify the importance of clarity, since responsibilities are shared between customer and provider. Control objectives ensure both sides know what must be achieved and how to demonstrate success. Privacy by design embeds data protection principles directly into system architecture rather than applying them as afterthoughts. This approach emphasizes minimization, purpose limitation, and data protection impact assessments, or DPIAs, as core practices. Minimization reduces the amount of personal data collected. Purpose limitation ensures data is used only for specific, lawful objectives. DPIAs evaluate risks of processing activities, especially those involving sensitive categories or new technologies. In cloud, this might mean designing services to anonymize analytics data or restricting geographic storage to comply with residency rules. Privacy by design is like building a car with seatbelts integrated from the start, rather than bolting them on later. By embedding privacy principles, organizations avoid costly retrofits, reduce regulatory exposure, and reinforce user trust. It shifts privacy from a compliance checkbox to a cultural value reflected in every system choice. Vendor and subprocessor due diligence ensures that external partners meet required security and compliance standards. Cloud services rarely exist in isolation. They depend on chains of providers and subcontractors. Due diligence evaluates their security posture, contractual commitments, and continuous monitoring capabilities. For instance, an organization may require vendors to provide SOC 2 reports, penetration testing results, and breach notification commitments. Subprocessor transparency is equally critical, since data may move through multiple unseen layers. Ignoring these obligations is like hiring a contractor without checking their licenses or references. Cheap in the short term, but risky in the long run. Proper due diligence strengthens resilience by ensuring partners do not introduce unmanaged risks. It also provides accountability, since clear contracts and ongoing monitoring define expectations. In regulated industries, vendor oversight is not optional but legally required, underscoring its centrality in Domain 6. Contract clauses are the detailed instruments that enforce governance in relationships with cloud providers. Beyond SLAs, they address audit rights, data return, deletion upon termination, and cooperation during incidents. For example, an organization may require that customer data be securely deleted within 30 days of contract end, with verification provided. Clauses may also grant customers the right to audit provider controls or receive third-party reports. Incident cooperation clauses obligate providers to notify customers promptly and share evidence during investigations. Without such terms, organizations may lack leverage during disputes or incidents. These clauses function like prenuptial agreements. They clarify responsibilities before conflicts arise, reducing ambiguity and protecting both parties. Crafting strong clauses requires collaboration between legal, technical, and risk teams, ensuring contracts balance enforceability with operational feasibility. They are the fine print that turns high-level governance into practical safeguards. Cyber insurance coverage complements technical and contractual safeguards by transferring some financial risk. Policies typically define limits, exclusions, and evidence requirements for claims. For example, a policy may cover costs from data breaches but exclude nation-state attacks or insider fraud. Evidence requirements often include proof of security controls, incident logs, and notification timelines. This means organizations cannot treat insurance as a substitute for diligence. Coverage is contingent on demonstrating responsible practices. Cyber insurance is analogous to homeowner insurance. It does not prevent fires, but it mitigates financial loss and requires fire alarms to be maintained. In cloud contexts, coverage must be carefully matched to risk profiles. considering potential liabilities from data breaches, service outages, or regulatory fines. Properly integrated, insurance becomes part of a balanced risk management strategy, complementing prevention and detection measures with financial resilience. Records management governs how information is retained, archived, and disposed of, ensuring alignment with legal and regulatory expectations. Retention schedules define how long records are kept, while disposition methods specify how they are securely destroyed. Legal holds may override normal schedules, requiring suspension of deletion for litigation. In cloud environments, records management is vital because data can proliferate across storage systems, regions, and vendors. Policies ensure that records remain available for compliance while avoiding unnecessary storage costs or risks from over-retention. It is similar to managing a library. Books must be cataloged, borrowed, returned, and eventually retired according to rules. Without structured management, information becomes either inaccessible or dangerously exposed. Effective records management demonstrates organizational maturity, proving that information life cycles are understood, controlled, and auditable. It ties directly into broader compliance and risk frameworks within Domain 6. Training and awareness programs equip staff with the knowledge and skills to fulfill their roles in legal, risk, and compliance management. Policies and contracts mean little if employees do not understand their responsibilities. Training must be role-based. Developers need to know about secure coding and data residency, while managers require awareness of risk reporting and contract obligations. Awareness programs also include phishing simulations, compliance refreshers, and scenario exercises. Think of training like safety drills in a factory. Workers must know not only how machines operate, but also how to respond when alarms sound. In cloud security, training ensures that GRC is not siloed in a compliance office but distributed across the organization. Well-designed programs create a culture of accountability, reducing both accidental violations and deliberate misconduct. Training transforms compliance from paperwork into daily practice. Compliance automation reduces manual error and speeds assurance by embedding rules into systems as code. Policy as code ensures that infrastructure cannot be provisioned unless it meets encryption or region requirements. Continuous monitoring tools automatically detect drift from standards, raising alerts or triggering remediation. This automation mirrors guardrails on highways. Drivers still steer, but rails prevent catastrophic veering off course. In cloud, automation is essential because environments scale faster than manual reviews can manage. By embedding compliance into workflows, organizations reduce latency between issue detection and resolution. Automation also generates consistent evidence, making audits smoother and less resource-intensive. While human oversight remains essential, automation ensures that compliance is not sporadic or reactive, but continuous. It transforms governance from static policy documents into living, enforceable mechanisms within the technical ecosystem. Audit readiness packages, controls, evidence, and walkthrough narratives in formats designed for external reviewers. Preparing for audits is not just about collecting logs at the last minute. It requires curated inventories of mapped controls, evidence repositories, and explanatory documentation. Walkthrough narratives explain how controls operate in practice, providing context auditors need to understand evidence. Audit readiness resembles preparing for a trial. Facts alone are insufficient without a coherent story connecting them. By maintaining readiness continuously, organizations avoid the stress and disruption of audit season crunches. It also demonstrates maturity, proving to auditors and regulators that governance is embedded rather than superficial. In cloud environments, where shared responsibility can complicate evidence collection, readiness ensures organizations can present a clear and defensible picture. This proactive posture turns audits from adversarial inspections into opportunities to showcase resilience. Regulatory change management recognizes that laws and standards are constantly evolving. Emerging rules on artificial intelligence, algorithmic transparency, and new data residency mandates illustrate how rapidly the landscape shifts. Organizations must track these developments, assess impacts, and update controls accordingly. Without structured processes, compliance lags behind law, exposing organizations to penalties and reputational damage. Change management includes monitoring regulatory bodies, engaging industry groups, and assigning ownership for updates. It is like weather forecasting. Anticipating storms allows preparation, while ignoring forecasts leads to being caught unready. In cloud contexts, regulatory change is especially complex because global services intersect with multiple jurisdictions. Proactive adaptation ensures resilience and demonstrates to regulators and customers that compliance is not static, but continuously refreshed. This agility is a hallmark of mature GRC programs. Regional localization strategies address jurisdictional differences by choosing data regions, key custody models, and access transparency practices. For example, European customers may require their data to reside within the EU, with keys managed locally. Transparency features allow customers to verify which jurisdictions accessed their information. Localization strategies are the cartography of cloud compliance. They map where data lives, who can touch it, and under what laws. Without careful localization, organizations may inadvertently violate residency requirements or weaken customer trust. Cloud providers offer tools for region selection and key management, but customers must align these to their own compliance obligations. Regional strategies illustrate how legal, technical, and risk considerations converge. They ensure that cloud adoption is not only efficient, but also sensitive to the diverse legal landscapes in which businesses operate. Metrics and key risk indicators, or KRIs, provide quantitative measures for compliance and risk performance. Metrics might track the percentage of systems with encryption enabled, while KRIs measure exception aging or audit finding closure rates. These numbers make governance tangible, turning abstract concepts into trends that can be monitored and improved. For example, rising KRI values for overdue exceptions may signal resource shortages or cultural weaknesses in compliance. Metrics act like vital signs in healthcare. They do not cure problems but indicate where attention is needed. In cloud environments, metrics ensure organizations do not simply trust that policies are followed, but can demonstrate adherence empirically. They also support board-level reporting, tying legal and risk practices to strategic oversight. Metrics and KRIs complete the feedback loop, linking daily operations to enterprise resilience. Anti-patterns in legal risk and compliance highlight behaviors that undermine effectiveness. Checkbox compliance treats audits as box-ticking exercises rather than opportunities for assurance. Unmanaged exceptions accumulate risk because deviations from policy are never tracked or remediated. Evidence assembled only at audit time signals immaturity, suggesting governance is reactive rather than continuous. These anti-patterns resemble bad study habits cramming before exams instead of learning consistently. They may achieve short-term appearances but collapse under stress. Identifying and correcting anti-patterns builds a culture of genuine compliance where assurance is a continuous process. Cloud professionals must recognize that shortcuts in GRC not only increase legal and regulatory exposure, but also weaken trust. By avoiding these traps, organizations strengthen both resilience and credibility, proving that governance is embedded rather than performative. From an exam perspective, Domain 6 emphasizes the alignment of legal mandates, risk appetite, and technical controls in cloud environments. Candidates must be able to identify how governance frameworks translate into controls, how contracts codify shared responsibility, and how privacy principles integrate into design. Exam scenarios often test recognition of which clauses or frameworks apply, or how to balance compliance with operational agility. The key is to connect theory with practice, seeing how laws and policies materialize into enforceable configurations, audit artifacts, and accountability structures. Exam readiness requires not just memorization but reasoning. Why a given control meets a risk objective, or how a clause enforces accountability. This synthesis mirrors real-world demands, where professionals must explain choices to auditors, executives, and regulators alike. Domain 6 reinforces that compliance is both a discipline and a skill in communication. In conclusion, Domain 6 integrates legal obligations, risk frameworks, and compliance assurance into a cohesive foundation for cloud programs. It ensures that innovation does not outpace law, that risk appetite is respected, and that controls are continuously verified. By covering governance, contracts, privacy, audits, and sector-specific mandates, the domain provides a 360-degree view of responsibility. Risk assessments, privacy by design, and vendor due diligence transform abstract principles into operational safeguards. Automation metrics and change management keep programs current and defensible. Most importantly, Domain 6 makes cloud operations lawful, auditable, and resilient. It proves that compliance is not a barrier to agility, but a guardrail enabling it. With these practices, organizations sustain trust, reduce uncertainty, and demonstrate maturity in both technical and legal dimensions of cloud security. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.